Hi, I'm Matthew Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about trademarks, and particularly we're going to be talking about trademarks in relation to goods and services. And it's a particular issue that's just come up, and it's in relation to real world and the metaverse. When you register a trademark, you have to register a trademark in relation to specific goods and services. And sometimes those goods and services are only covering what you're actually manufacturing. In America, they've actually had a case where Gucci, who makes handbags, has registered a trademark for handbags. But somebody went through and tried to register a trademark for a virtual handbag in the metaverse. And the question is whether a virtual handbag is the same as a real handbag. Whether a virtual handbag is just software or just a drawing. It's not even a real handbag. So really, when you register a trademark, is a court going to confuse a real good for a virtual good, considering that they'll be in two different kinds of classifications to start off with under the trademark system? In the US Patent Office has found that the virtual goods are the same or closely related to the actual goods. So in the case of Gucci, they've actually said that they've stopped this trademark from going through based on the fact that it was closely related. Now the problem is that in every other jurisdiction in the world, it's completely untested at the moment. So we don't know how other jurisdictions are going to deal with this problem, and I have a feeling they're not going to deal with it in the same way as what the US has dealt with it. For instance, in Australia, I doubt that an examiner would block a trademark if you filed a trademark for Gucci for software and didn't make any reference to handbags in the list of goods and services. So this is something we really have to consider, particularly if you're filing new trademarks, and particularly with fashion goods such as shoes, handbags, t-shirts, clothing, whether you should be thinking about, maybe I should file it in the software class. Maybe I should be filing virtual clothing as well as real clothing. I hope this gives you something to think about when you're applying for new trademarks, and think about the consequences of the actual metaverse on new trademark applications. If you want any more information about the metaverse or trademarks or how they interplay with each other, please feel free to contact myself or the rest of the team at Alder IP. More than happy to help you. And thanks for listening.